not a webinar which I'm conducting on any technical topic. It is basically an experience, a journey for an issue which I would want to share. And today I would, through the medium of a storytelling session, will tell you that how this has happened and how several thousand assessees will today get the benefit of the order which we have got in Delhi High Court, other courts, and Supreme Court finally. As you are aware that our nation this year celebrates AZADI Ka Amrit Mahotsav. And I want to take a pause and talk about AZADI Ka Amrit Mahotsav. What actually is this? What is Azadi? And why today our Prime Minister wants to celebrate this AZADI Ka Amrit Mahotsav? And let me be very frank, let me be very honest. And because today we are talking about taxes, tax reforms, the Prime Minister has very categorically in his AZADI Ka Amrit Mahotsav has very categorically said that we are proud of our constitution. I repeat, we are proud of our constitution. He goes on to say that the mother of democracy, India, is still moving forward by strengthening democracy. And why that is important? Today that is important because we all have seen tax reforms. We all have seen a lot of these problems which taxpayers may have faced. But we must understand that this GST reform is not any normal reform. This is an extraordinary reform of the century. With our Prime Minister's vision, what he intends to do, he intends to create ideas at 75, actions at 75, achievements at 75. And some of these tax issues which have gone to the government, today we are a proud nation to witness that how government under the leadership of our Prime Minister is moving towards pragmatic solutions. Transitional credit resolving this issue is one such example. And I can tell you a lot of other examples also with respect to coercive measures and recoveries, with respect to circular trading. We have already seen instructions and circulars have come. This is the idea at 75 and action at 75 which this government wants to take. For some reason, if that is not implemented correctly at the ground level, of course we have the finest judicial system of the world in our country. We have one of the best legislation in the country today because GST has not come up like that. GST has come with a lot of innovative thinking, a lot of innovative ideas. And we must not forget that we are a federal structure. Different states have to come on board. There could be different diversities. And for that implementation to happen in the country, it is not easy. But as the GST moves beyond 5 years, in light of our Prime Minister's vision, AZADI Ka Amrit Mahotsav, there are a lot of changes which are happening. The government is coming out with a lot of practical solutions. How to address coercive recoveries, how to address circular trading issues, how to address transitional credits. I also understand that there will soon be a circular on arrests. What must happen, and so on and so forth. With that background, let's move to yesterday's Supreme Court decision. But before we move to that, it is important for us to understand that what are these transitional credits? And when we say transitional credits, please note that the Supreme Court decision will not only help 8 to 10,000 taxpayers who are struggling with transitional credit. This landmark decision will help in several other cases wherein the principles with respect to vested rights, principles with respect to transitional credits will all come into play. We must not forget Section 174 of our CGST Act, and which says that anything which affect any right, privileges, obligation or liability acquired, accrued or incurred, all of these are protected under the new law. The problem comes when we look at from a very narrow vision. We have to look the problems today what are coming before the taxpayers with a holistic approach, harmonious approach, with constitutional lens. And I remember when this matter in case of brand equity came to me, client had already met several other advocates and law firms. And they came to me that there is a time limit prescribed. And as per law, we have missed it. So what is the remedy? If we see specifically the time period of 90 days mentioned within the rules, there is no remedy. But can we have that narrow approach? Or do we need to analyze all my rights under the statute, my rights under the Constitution, what I get under the Constitution, and what I get under this GST law? And I frankly asked the client that time that what happened. He said, we missed the deadline. We forgot it. He said, we missed the deadline. And those days in 2017, this Tran 1 date was getting extended because of a lot of technical glitches. System was not ready. Millions of transactions were happening. 1.3 crore taxpayers were using the GST network. And hence there were a lot of, and quite understandably, there were a lot of technical issues. Would this problem fall under technical issue? Technically, the answer could be no. This is not a technical issue. It is not a system issue. But this is a bigger issue. And what is the bigger issue? That the entire tax system has changed. These are not normal circumstances. These are extraordinary circumstances wherein everybody is learning. GST network is learning, taxpayer is learning, the authorities are learning, legislative framework is getting developed, GST council is meeting very often to address these issues. And hence it is not normal. It is extraordinary situation. And I explained this to several of my clients, that this is not an ordinary situation. Now, how do we then step in to get your rights protected? So the first and the foremost question, and this is all part of the brand equity decision of Delhi High Court, a decision worth reading, my friends. 2020-116 taxman.com 415 Delhi. Please note the citation. 2020-116 taxman.com 415. A decision worth reading not only for transitional credits, but for several other issues for which it will be used. So, when we were discussing and deliberating on the issue, The first and the foremost question which came, and this is relevant not only for transitional credit, but for various other issues. How are my rights protected under the current law in terms of Section 174? And I've seen in a lot of cases, people miss 174. You can't miss 174 if something relates to the past which comes to the present. It is just like preparing yourself half-heartedly. 174 gives you the right and protection with respect to what has accrued or would have accrued to you in the earlier regime. And hence, if we talk about transitional credits, the first and the foremost point which comes is that what are these credits? What are these transitional credits? What are these transitional credits? Let's just understand this first. These transitional credits are nothing but my money in form of credit, which got accrued to me in the previous regime. So you could divide that into two aspects. One could be hardcore credit, like for example, I was a service provider and I had the credit balance, the closing balance, which I disclosed in the service tax return. So these are transitional credits availed or accrued to me in the earlier regime. This could be one basket of credits. The second could be with respect to those goods. Suppose I'm a trader. I deal in laptops or I deal in certain other products which were not taxable. And these goods now are subject to tax. I may have an invoice, I may not have an invoice. Because these goods were subject to erstwhile taxes, some form of the taxes. But for some reason, I was not required to either take registration or there could be different combinations, permutations and combinations. This credit was not relevant for me. But on the transitional cutoff date, this credit becomes relevant for me because now going forward, these goods will be subject to tax. So handbags, traders in cases of shoes and a lot of other products, it became relevant. So the government provided these transitional provisions. So in terms of credit, which was availed, you fill trans 1, take the credit, disclose that credit. In terms of the details of the goods, you provide these details of the goods on which you have incurred cost, taxes, erstwhile taxes. But these taxes must come into the tax chain by way of transitional provisions so that you get some part of the credit, and there were formulas, 40%, 60%, IGST 30%, and so on and so whatever that formula. So these were the transitional credits. The moot point which arises is that with respect to the credit per se, which is nothing but my cash lying in the accounts, or with respect to the goods on which I have borne some sort of taxes, the right accrued under the erstwhile regime. Now, for something for which the right has accrued, the question which comes is that for technical or non-technical glitches, is there a vested right with respect to such credits? And hence it was important to go beyond the provisions. It was important for us to understand the circumstances. This is not a reasonable situation. And this is what was argued. Delhi High Court very categorically, I still remember, says transitory provisions, as the words indicates, have to be given its due meaning. Transition from pre-GST regime to GST regime has not been smooth. These were our arguments which ultimately came in the order. And therefore, what was reasonable in ideal circumstances is not in the current situation. Please note, my friends, very important part of the order. And therefore, what was reasonable in ideal circumstances is not in the current situation. These are not my words, my friends. The court has noted this down. The question then which came with respect to the period. First, can the delegated legislation prescribe a period? And I very categorically remember I argued this in court that for all other statutory periods, the statute provides for the period. For this transitional credit, the time limit is prescribed in Rule 117. And hence, the entire controversy, if I could summarize, was on 3 important points. And my friends, all of these 3 important points will be relevant not only for these transitional credits, but for plethora of these cases which are pending today. First is arbitrariness of the time limit prescribed by way of delegated legislation. Second is my vested right which accrues to me. Third, the foremost, is applicability of Article 300 capital of the Indian Constitution to protect my right with respect to my properties. And hence, the important question which came before the court was that, and we remember a very, very interesting discussion and debate happened. If there is no time limit, if there is no adequate time limit prescribed, or if the time limit is coming through the rules, then what should be the time period? Very interesting aspect. For the first time in case of Brand Equity versus Union of India, 2020, 116 taxman.com 415 Delhi, it was held that the Limitation Act will come into play. And that is history, my friends, that is history. This decision will go down in the history books, not only for applicability of Article 300 capital A, reading down 117 rule, delegated legislation, but for the first time, Limitation Act comes into play for the taxation provisions. And it is worth to read those parts of the decision which says, and I remember, in absence of any specific provision under the Act, it was held by the court that in terms of the residuary provisions of the Limitation Act, the period of 3 years should be the guiding principle. My friends, please note that. the residual period of 3 years under the Limitation Act should be the guiding principle. And thus, a period of 3 years from the appointed date would be the maximum period of availing of such credit. So there comes a guiding principle, Limitation Act. A lot of these things, when you're filing a petition in the first go, you would not think about that. But you are forced to think about those rights, other acts, as and when you are arguing before the courts. And we had the experience of arguing before the best judges of the country, best judges. Limitation Act becomes the guiding principle. Vested rights for credits comes into play. Article 300 capital of the Indian Constitution comes into play. And the court reads down Rule 117 for prescribing 90 days. That was the beauty. Please, if you love indirect taxes, if you love GST, please go through each and every word of Brand Equity versus of Union of India, Delhi High Court decision. So what happened? What court basically held? That insofar as Rule 117 prescribes time limit of 90 days for transitioning of credit, it is directory in nature and would not result in forfeiture of rights. Please note that. Why this decision is very interesting? Not because I argued that, but because it has got a couple of very interesting aspects held by the court. The court goes specifically ahead and says, insofar as Rule 117 prescribes time limit of 90 days for transitioning of credit, it is directory in nature and would not result in forfeiture of rights. Please note that. The court says that it would not result in forfeiture of right in case credit is not availed within the prescribed period. And then the question comes, can we go to perpetuity to claim this? Court said no. You can't. It cannot be in perpetuity. And rightly so. And that's when the Limitation Act came into play. And the court said that this does not mean that availing of Senvet credit can be in perpetuity. And hence, Limitation Act comes into play to prescribe that period of 3 years. And the court said a period of 3 years from appointed date would be the maximum period for availing of such credit. Interestingly, Rule 117, whereby mechanism for availing credits has been prescribed, is procedural and directory and cannot affect substantive right of registered taxpayer to avail of existing accrued and vested Senvet credit. So the court went on to say that it cannot affect 117, the rule, the delegated legislation cannot affect substantive right. Procedure cannot run contrary to the substantive right vested under Section 140. So, very interestingly, the debate went to the rights. to substantive right, and whether the rule which prescribes a time limit can defeat the substantive right which accrues to me, was one of the very, very important aspects, substantive right. Because today what we are arguing in most of these petitions, transitional credit or others, and I have received lot of phone calls, messages from my followers, from my friends, from my clients for these substantive rights. I will cover some of these issues. So today, substantive rights and protection of these rights is given utmost importance. And I again emphasize that as we celebrate 75 years of independence, even Prime Minister Modi knows the importance of our constitution. That's why this has been mentioned time and again. So my substantive rights, my constitutional rights are all given huge importance in today's system. To conclude what happened in brand equity, Delhi High Court read down 117 as directory in nature, insofar as it prescribes the time limit for transition of credit, and held that the same would not result in forfeiture of the rights when credit is not availed within the prescribed time period. So that was finally held. Now let's come to the SLP and what Supreme Court has done. The fundamental aspects which were raised were very strong legally in terms of the constitutional provisions and the rights. And hence we must acknowledge the efforts of the GST Council and the efforts of this government, which is coming out pragmatically to get these issues resolved through judicial system. And when this matter came before the Supreme Court yesterday, I think we must appreciate the efforts of the government, because they want to pragmatically address these issues. And if such an order comes to the Supreme Court medium, it becomes binding on all different courts, on all lower forums, on adjudicating and appellate authorities, because now it comes from Supreme Court. And hence these 5-6 points are relevant in terms of what has been held. Supreme Court very categorically says GSTN portal should open the common portal for all SSEs. Please note, it says for all SSEs. During the course of the argument yesterday in Supreme Court, the learned ASG very categorically mentioned about my order, in which Delhi High Court had said that it must extend not only to the petitioners, but to everybody. In fact, Delhi High Court had gone ahead to say that this order must be publicized. This order must be publicized so that it reaches the larger audience and everybody is able to get the benefit of that order. To honor my Delhi High Court order, which was mentioned yesterday by the learned, very, very learned ASG yesterday, it has been now part of the Supreme Court order that GSTN portal should open for all SSEs and not only to the petitioners who are before Supreme Court or pending before several other courts. So all SSEs get the benefit from our efforts to claim transitional credits, and they have given a window of 60 days. So the portal opens for 2 months. I think the date is 1st of September 2020 to 30th of October. The portal opens for 60 days. All SSEs can claim benefit whether they have filed writ petition or not is clearly mentioned. GST network would ensure that there are no technical glitches, of course, because a lot of people may come and there could be some glitches. So they must ensure that there are no glitches. 90 days period is given to officers thereafter to verify the claim of credit on merits and pass appropriate orders in accordance with law. This is mentioned by the court, in accordance with law, on merits and in accordance with law. Because if legally it is not permissible or some other reason, that has to come into play. Then the request was made that in case of rejection, there must be an opportunity of hearing, which also forms part of the order, that there should be reasonable opportunity of hearing to be granted. And after all this happens, the credit must reflect in electronic credit ledger. And of course, GST Council can issue directions to field officers. So if we now see some common pointers between the landmark decision in case of brand equity and the Supreme Court decision. Respondents are directed to either open the online portal to enable the petitioners to file declaration in Tran 1 electronically or to accept the same manually. So that comes. So the Supreme Court goes a step ahead to say that there should not be any technical glitches. So it becomes open. The portal becomes open to everybody. Respondents shall thereafter process the claims in accordance with law. This is what Supreme Court says, and that's what was the endeavor of Delhi High Court. The related point is that other taxpayers who are similarly situated should also be entitled to avail the benefit of this judgment. This is part of the Delhi High Court decision. And these are specific words. Other taxpayers who are similarly situated should also be entitled to avail the benefit of this judgment, the Delhi High Court judgment, brand equity. Therefore, respondents are directed to publicize this judgment. Please publicize, it was told. Publicize this judgment widely, including by way of publishing the same on their website. This was the direction given by Delhi High Court. Publicize this judgment widely, including by way of publishing the same on their website, so that others who may not have been able to file Trans 1 are permitted to do so on or before a specified date. So Delhi High Court very, very categorically and very, very correctly and pragmatically said that please publicize this decision, this judgment. Publish it on your official website. Give the benefit not only to these but also to others. And hence, the broader question was before the government, before the GST Council, that in light of such a judgment, how these issues must be addressed. Unfortunately, Retrospective amendment happened in section 140, subsection 1. Some petitions which came to me after brand equity, we have even challenged the retrospective amendment of section 140, subsection 1. Because any retrospective amendment which comes into play subsequent to the court order must not defeat the purpose of the court order. Also, any retrospective amendment which comes must come in rarest of rare circumstances. And we will argue that in this case or some other case. I think this case will now, this argument will not be required, because even in cases of retrospective amendment becoming applicable, in case of that 3-year period becoming lapsed, and so on and so forth, today, in this window of 60 days, all SSCs can claim the right. It is my duty to inform to my participants today that the court very categorically said that in case you do not get the relief, you have the liberty to approach the court in case of injustice. Because it was specifically being argued that should it be specifically written in the order that this decision be binding on all several pending matters and courts and so on and so forth. But in any case, Supreme Court decision is binding. And hence, the court felt that if on merits or in case of difference of opinion, there is some issue, then of course, the petitioners or the taxpayers will always have that right to approach their jurisdictional court and of course the apex court at appropriate point of time. And hence, I feel that in spite of the retrospective amendment which has come to section 140 subsection 1, there must not be any difficulty. We must please note that section 140 subsection 3 had a slightly different challenge. Credit with respect to invoices more than 12 months old or 6 tax periods. That aspect is more from the perspective of Tran 2, still is a vested right in terms of the goods, invoices, old tax periods, and so on and so forth. Fundamentally, these situations get covered by Supreme Court order. I would go even beyond this. That what happens in cases where the period is beyond 3 years? Please avail the benefit in these 60 days. I have few petitions where we have challenged the right which must accrue to me if I have not availed that within 3 years also. In light of the Supreme Court decision, it becomes important for us to avail the benefit which has been extended to me by Supreme Court and now file my claim in this window when the GST network opens, even if it is beyond 3 years. There are few peculiar situations which I am arguing, very, very unique transactions of Trans 3. A lot of people may not have even heard of Tran 3. Tran 3 credit comes in those situations wherein the value per goods per item is more than 25,000. And these are identified goods. So what happens in case of a tractor or a car, where there is a chassis number, or a mobile where there is an IMEI number, and these are identifiable products. Transitory credit comes to those commodities. Interesting aspect. While these writ petitions and these findings and everything is with respect to Tran 1 and 2 predominantly, what happens to Tran 3? And today, I think we are not bothered about Tran 1 or Tran 2. We are today happy as professionals from the guiding principles which come by way of the Supreme Court order. With respect to my vested rights, with respect to protection under Article 300 capital of the Indian Constitution, with respect to the delegated legislation being read down, and the fundamental aspects that this was a reform of extraordinary nature. Technical glitches, non-technical glitches, all must be addressed. And hence even very few, and I think I have few participants who have Tran 3 problem as well, and I'm arguing that matter in Bombay High Court. Even the pending matters for Tran 3 would get the benefit by opening of this portal subsequent to the Supreme Court order. And in any case, the court has said that we have the liberty to approach court in case of injustice. And that in any case is my right. So that becomes an important aspect. I received a lot of calls in last 24 hours with respect to other rights, the credits, how they are my vested rights, blocking of credits, are these my vested rights? Rights which are accrued under the earlier regime. For instance, if we see the scheme of advance authorization, you had to meet the export obligation if you claim the benefit of advance authorization. And if you do not meet that export obligation, then under the previous regime, you had to pay interest, but you could avail the credit. The important aspect which is coming today is that what happens in those situations wherein the provisions after the transition, which means the current provisions, do not allow me to take credit with respect to non-fulfillment of export obligation when these advance authorization licenses were issued prior to the GST regime. I'm arguing such matter in Delhi High Court. I received few queries today from Punjab and Haryana. My decision in case of brand equity and this Supreme Court decision of mine will certainly help such situations. Because the court has very categorically said that these are vested rights. The court has gone into analyzing section 174. Now, if we talk about this specific situation, the right to avail credit with respect to advance authorization licenses, in case I'm not able to meet the export obligation, accrues to me in the previous regime. If that right accrues to me in the previous regime, and that right is to right to credit in case of non-fulfillment of export obligation, then that right which is accrued in the previous regime must continue. And any provision which defeats that right of availing credit after the transition affects my right, contravenes the provision of section 174, contravenes the provision of Article 300 capital A, contravenes the provision of Article 14, Article 19 1G, of the Indian Constitution. And I'm saying that with full responsibility. Article 19 1G comes into play because it impacts my business. It impacts my right to carry on business or profession because I will be completely out of pocket, and these are not small numbers. Article 14 with respect to arbitrariness comes into play. Arbitrariness of a provision gets tested and will have to test the constitutional borders under Article 14. And hence, my dear friends, this decision will not only help these 8 to 10,000 taxpayers for these transitional credits in form of Trans 1, Trans 2, Trans 3, but will substantially help to resolve other issues, other tax situations, wherein the fundamental aspect of vested rights come into play. With that, I will take a pause and we will just go through some of these questions if there are any. Jairamji is writing, sir, we have already filed Tran 1. Can we revise the Tran 1 form based on today's order? Yes, my dear friend. You can certainly do that. Please revise the Tran 1 form based on this order. Give everything very correctly now. If your Tran 1 form is only for the credits which you had disclosed in the earlier returns, the right had accrued that point of time. If this is also with respect to certain goods, etc., please do that. And please give all disclosures, because there may be scrutiny of the claim or whatever. It is our duty to give all appropriate disclosures. We are checking all. I think there are not many questions. Possibly it appears that I have answered most of these questions. There is one more question in the chat box which has come. It says, there are two more questions. The first question I'll read, that the issue is that in case of surrender of EPCG scheme where the capital goods are imported prior to GST regime, but the same is surrendered post GST due to non-fulfillment of it. I think I have answered this. Even if it is with respect to capital goods, you will get the credit, because capital goods also you get the credit, being a vested right under Article 300 capital A. Very, very categorically it is mentioned, as held by the Honorable. Absolutely. Absolutely right, my friend. And I think it's one of my very close friend, Rishabh Kapoor, who has written this. Rishabhji, what you are saying is absolutely right. It gets the protection under Article 300 capital A. This Supreme Court decision will certainly help. And Rishabh is very categorically writing, as CVD and SAT tantamount or subsumed to IGST as per the old and new regime, the SSE is allowed to avail the credit of the duty component. Absolutely, you would get the benefit. Arshika Bhardwaj is writing, request your views on the limitation placed in the GST Act to reclaim earlier reversed credit by making payment to supplier within 3 months from appointed date. This right of making payment and reclaiming credit was available perpetually under the service tax regime. Any right which accrues to me under the earlier regime continues through possibly the medium of this decision. And we will have to, and you are very categorically writing that this was available perpetually under the service tax regime. We will have to ensure and check that what provisions were applicable, how these were applicable, what was the periodicity, frequency, and so on and so forth. My rights which I had with respect to these credits under the earlier regime cannot be curtailed in the current regime. Then there is one more question from Advocate Punalkar. We have succeeded before High Court, Mumbai. Is there any chance of approaching before Supreme Court by department? I don't see that must happen. But even if that happens, this decision of yesterday can be used. But what I suggest is that in the meanwhile, if that happens or that doesn't happen, please don't miss your deadline of 60 days and that window of 60 days. So that if it is not, it must all be on record. I do not know the status of your claim currently, but it must all